and I'm a judge from neighboring Croix County. For my out-of-county assignments, I normally hold court in the county where the case is venued. However, earlier this year, the Chief Judge for the 10th Judicial District, which includes Polk and St. Croix counties, issued an order that restricted out-of-county travel. The order was made to mitigate the effects of and spread of COVID-19. Although the Chief Judge has the ability to make certain exceptions and allow travel, my court calendar today in St. Croix County did not permit me to do so. That is why we're conducting this hearing today by Zoom. We are also live streaming these proceedings on YouTube to allow members of the public to view and observe. Additionally, my courtroom is open to the public, and we do have at least one member of the public viewing the proceedings in person. I also want to note, too, that the Supreme Court of Wisconsin had issued an order requiring all persons attending court in person to wear masks. That's why I'm wearing my face covering. That's why the member of the public is also wearing face covering, and I thank him for that. Now, to the matters at hand. The main issue today is the motion for a temporary injunction. I did receive late last week a motion to file a non-party brief. I don't believe we have counsel for the Wisconsin legislature on the call, but Mr. Hector, I'm going to give you an opportunity to comment on the request if you feel it appropriate.
The DOJ does not oppose the request to file an amicus brief, Your Honor.
Okay, thank you. And my reading of the motion is that solely to file the brief. It was not to intervene as a party participant, and that explains their non-appearance for this hearing. Let's turn to the motion for the temporary injunction. I did read the briefs. They were all very well written. They were very helpful to me in understanding the issue and understanding the points of law that you believe are applicable. I'm still interested in hearing oral arguments. But I want to toss out something that I have been wrestling with over the weekend, and I want to have the attorneys address this in some form or fashion during their arguments. And the point is this. The legislature in section 323.10 granted the governor the power to declare a state of emergency through an executive order. That order can only last for 60 days. The legislature in the same statute reserved to itself the ability to extend the order. It also reserved to itself the ability to terminate the order. Now, in this motion, oh, and I should add too that the legislature's powers in that regard appear to be without qualification, meaning the legislature can extend or terminate a governor's declaration of a state of emergency at any time and apparently for any reason. Now, the plaintiffs in this case are asking for an injunction. So they're asking the third branch of government, the judiciary, to step in and exercise a power that the legislature reserved to itself. And the court is being asked to do that when the legislature apparently has chosen for one reason or another not to act, at least thus far, as it relates to Executive Order number 90. So I guess the concern that I have is twofold. Number one, is there a justiciable controversy? And then number two, is the relief a violation of the separation of powers? In other words, asking the judiciary to take unto itself and exercise a power that the legislature expressly reserved to themselves. So that's what I've been wrestling with over the weekend, and I really would like to hear your opinions about those topics. So Mr. Lococo, I'll let you speak first, and you're certainly free to address any of the other points that you feel are relevant regarding your motion.
Thank you, Your Honor, and I'll certainly address the question you raised during the course of my argument. This case is not about whether COVID-19 presents a serious public health challenge. There's no dispute here that it does. This case is also not about what measures Wisconsin should take to respond to COVID-19, specifically whether the imposition of a statewide mask mandate is a good idea. It may well be. What this case is about is who decides how to respond to an emergency in Wisconsin and under what procedures. The legislature addressed this question ahead of time in Chapter 323 and adopted a framework that balances the need for quick action with the need for checks on the exercise of extraordinary emergency powers. Here's the framework. When disaster strikes, the governor via executive order may declare a state of emergency and obtain a 60-day period of time to exercise enormous power unilaterally, avoiding the normal constitutional process. That grace period provides the legislature, the executive branch, and municipalities with the breathing room they need to work on more permanent solutions through legislation or rulemaking. But because these powers granted by the legislature are so broad and thus susceptible to abuse, the ability, for example, to unilaterally decree that 6 million Wisconsinites must remain in their homes till further notice, the legislature has imposed an important check on them. The state of emergency may not exceed 60 days unless extended by joint resolution of the legislature, no other exceptions. This makes sense. If the emergency is truly of a nature that Wisconsin needs the governor to have more than 2 months to act unilaterally, the legislature will vote to extend. If not, it won't. Now that's the framework. We could debate its wisdom all afternoon, but ultimately it's the law. It's the law, but in this case, the governor disregarded it. When COVID-19 hit our state early this year, the governor used Section 323.10 to declare a state of emergency and order Wisconsinites to remain in their homes, among many other things, including closing businesses, and we all remember that. That declaration was issued in March, and it expired in May. Now, during this period, the governor had a choice. He could have worked with the legislature to pass a law. He could have promulgated an emergency rule that would have lasted another 150 days. He could have decided to leave most policy questions to local government entities based on the specific circumstances of each area. These options all share something in common. They involve the input or cooperation of other governmental entities as well as the public. But he's done none of those things. Instead, even though we were dealing with the exact same pandemic, and even though the legislature had not authorized him to do so, the governor simply declared another state of emergency 2 months after the first 60 days expired in July, along with a statewide mask mandate. And then he declared another state of emergency when that one expired in September. Now, presumably, we should expect another declaration after that, and another after that, continuing for so long as the governor deems that circumstances warrant it, and henceforth simply live by gubernatorial decree. The statutes at issue clearly don't permit this. There's a hard 60-day time limit on the declaration of a state of emergency without exceptions for whether the emergency gets better or worse, which is obviously something emergencies sometimes do. The pandemic that we had in July and September is the same one we had in March, even though it has fluctuated in severity. It's the same essential public health problem, the spread of a novel virus. As the Supreme Court wrote in Palm at paragraph 41, quote, in the case of a pandemic which lasts month after month, the governor cannot rely on emergency powers indefinitely, end quote. Now, looking at the text of 323.10, the canons of statutory construction all point in the same direction here, and there are 4 in particular that apply. First, the expressio unius canon says that where the legislature provides an exception to a statute, other exceptions are impliedly excluded. Here, there's one exception to the 60-day limit, extension by joint resolution of the legislature. There is thus no exception for situations where the emergency gets worse, again, even though that is something that emergencies sometimes do. Second, the surplusage canon says that we avoid interpreting statutory language in a way that will give it no effect. What is the point to a 60-day limit if the governor can simply renew it at will? That would render the language meaningless. Third, as the legislature points out in its amicus brief, the so-called knew how-to canon says that evidence that the legislature knew how to include a provision but did not is evidence the statute was intended not to include that provision. In other words, here, the legislative history indicates that Section 323 is modeled after the Model State Emergency Health Powers Act. That act includes a provision that permits a governor to keep his or her state in a state of emergency indefinitely. And while other states have included that provision in their emergency powers framework, Wisconsin has not. It includes the 60-day expiration date, and that strongly suggests the choice was intentional.
Can I ask a question?
Sure.
Can I ask a question on that point? I
Yes,
only
sir.
am going to be able to consider the statutory history or the legislative history if I find there's an ambiguity. Would you agree?
Yes and no, Your Honor. The Wisconsin Supreme Court has written that legislative history may be considered for confirmatory purposes, even when the language is unambiguous. But I agree in the normal run of things, if you find that the language is unambiguous, as the plaintiffs view it to be, there is no need to go to the legislative history.
Okay. Do your clients consider the statute to be ambiguous?
No.
Okay. All right. Thank you.
Finally, the fourth statute, canon of statutory construction, and this dovetails with the second issue the plaintiffs raised in their complaint. There's a massive constitutional avoidance issue here. Where two interpretations of a statute are available, we generally err on the side of the one that doesn't raise significant constitutional questions. But if the statutes permit the governor to declare emergencies arising from the same state of affairs in series, one after another, then the pandemic or any other emergency will have been permitted to override the rule of law and our constitutional separation of powers. Our state constitution vests the legislative power in the legislature, not the governor. The legislature is not permitted to simply give away that power, the power to effectively legislate as to any matter deemed necessary for the security of persons and property, without effective procedural safeguards such as the 60-day time limit. So if this court concludes that the legislature has delegated its legislative power in this way, it should find the statute unconstitutional. But the better approach is to presume that the legislature did not draft an unconstitutional statute, that it limited these declarations to 60 days absent legislative renewal. Now, on the merits, the governor's responses to this unambiguous statutory language are actually limited. His position, and I'm quoting here from page 36 of his brief, is that, quote, the statute therefore must be construed to allow the governor to declare a state of emergency on any given date based on an event that poses a particularly grave danger, full stop, end quote. The governor will virtually always be able to fulfill this standard. With respect to COVID-19, for example, justifications for unilateral extensions could include cases spiking, hospitalizations surging, particular age groups suddenly being affected, winter or spring bringing along additional sicknesses, the virus behaving in an unexpected way, and the opposites of some of these things might also work. For example, what if cases are rapidly decreasing? Perhaps the governor would argue that we need to seize the moment and issue another state of emergency while we can. This interpretation offers the governor almost unlimited unilateral power. Emergencies rarely stay the same. They get better or they get worse. And yes, they're unpredictable. The legislature knew all that when it drafted the statute, and it still imposed a 60-day limit. That's because the legislature itself can choose to extend the emergency declaration if it wishes to, and because other avenues of relief are available to the governor, such as legislation and rulemaking.
Okay, but isn't the check against that abuse of power the legislature's own ability to terminate the executive order declaring the emergency at any time?
Your Honor, the governor writes about that check as if it's a silver bullet, and it's not. And the legislature itself tells us in an amicus brief it's not. There will be times, for example, where the legislature might be unable to agree on whether to rescind the declaration. And even if they do rescind, the governor may simply tweak the emergency declaration and redeclare. And I think that's why the legislature created the framework that it did. It could have created a system whereby the declaration renews unless rescinded by the legislature. But it told us in the statute that it wants the default to be that the declaration expires after 60 days unless renewed. In other words, the legislature's already spoken. It's told us that inaction by the legislature must be read to mean that the legislature does not consent to a renewal. Now, Your Honor.
Okay, I'm not sure that answers the question though, because if we had an abuse of power like you described, the legislature could simply pass the joint resolution. It doesn't need governor approval, so there's no worry about a veto. And if the legislature, for reasons, divided government, the votes aren't there or whatever, but those are political ramifications that the voters address at the ballot box, isn't it?
No, Your Honor. I think that if you're thinking about political accountability here as a procedural safeguard, That comes in when the legislature actually has to take an affirmative action. When the current state of affairs allows the governor to continue redeclaring, the legislature doesn't have to do anything. That's not an effective procedural safeguard. And I think that we need to take a step back and think about what the governor is saying here when he says that because of this check, the matter is not justiciable. He's saying that he and the legislature can form an agreement that he may by decree order citizens to do whatever he deems necessary for the security of persons and property. And those same citizens may not challenge the source of authority, and a court may not review that challenge because they together have decided that their conduct is unreviewable. That's not how the separation of powers works. This is a statutory interpretation question, a constitutional question. That's exactly the kind of issue that courts review all the time. Now, returning to the merits, Your Honor, unless you had a follow-up question on that.
No, I might, but continue on with your arguments.
The governor provides a number of hypotheticals that aren't present here. We don't deny that there may be circumstances where it's unclear whether the original emergency has abated or been controlled, or unclear whether some intervening bad event itself constitutes an independent disaster. But those cases can be saved for another day. Here, there's no dispute that we're dealing with the same virus that we were on day one. The virus is ever brought under control and years later returns, the governor may well be able to reactivate his powers. But again, all agree, and the governor's own evidence shows it, that with some limited fluctuations, the pandemic has continued to worsen since March, despite the governor's efforts. The governor wants more time to do more of the same. That's a policy question now up to the legislature. Section 323.10 makes that very clear. With the court's permission, I'll briefly talk about the other injunction factors.
Sure, go ahead.
I'm a little surprised here to see the governor contesting the presence of irreparable harm. I recognize that wearing masks has become more common in 2020, but the government is still ordering its own citizens, my clients, to put something on their faces, over their mouths. That's a significant assertion of governmental power when you think about it, and arguably a somewhat invasive one, even if it's a good idea. We don't measure legal harm by whether something actually hurts. Trespass on one's property or a pat down by law enforcement may not always look like injuries, but we know that they are. They're intrusive actions. The same is true here. We certainly understand that for many people, wearing masks is simple. It seems like the smart, safe, and courteous thing to do. They may not care that the government is ordering them to wear masks, but my clients do care, so they are aggrieved by this invasion of their liberty. The governor also argues that my clients are just trying to obtain their ultimate relief faster. They made the same argument with respect to the status quo. That totally misapprehends the nature of the harm. Every day that my clients are forced to comply with this order is a distinct harm. It's a day they will not get back. If the government were forcing the plaintiffs to take medication every day, we wouldn't say that the harm is reparable simply because if they win, they can stop taking it. Of course not. The legal harm is occurring now, and it can't be undone by a later ruling. On the equities, the governor cites his interest. Yes, Your Honor.
Can I just go back 1 second?
Sure.
One thing I've wondered about, and I also anticipate, is that no matter what I decide, there's going to be an appeal to a higher court. This is just the first step in probably a longer process. Usually courts are reluctant to grant the ultimate relief on a temporary basis. What is it going to take to get this case to the point where we can have a final adjudication, where there's a final order that is appealable as a matter of right, and get the case continuing on to wherever it's going to go? What else do we need to do in the record to get to that point?
I mean, certainly in the plaintiff's view, this is a legal question, statutory interpretation question, a constitutional question. So I think that question is probably better directed to, so I would say little on our part, but that question probably depends on what the governor intends here. The governor is making the argument that changing scientific circumstances or changing circumstances regarding to the emergency affect whether relief is appropriate here. So I don't know whether the governor intends to put in additional evidence and whether we might want to take a look at that.
Okay, thank you.
Now on the equities, the governor cites his interest in combating COVID-19. And obviously we don't dispute that such an interest exists and it should be given consideration by the court. But there are three important pieces of context here. First of all, the interest doesn't belong to the governor alone. It also belongs to the legislature, the holder of the general police power, and to the hundreds of municipalities in Wisconsin. There's a giant dog that's not barking here, as the court has noted. If the legislature agreed with the governor's view of the need for emergency powers, it would have extended them. It has not done so. By the same token, we know that some cities have imposed mask mandates that aren't being challenged here, and other cities might yet decide to adopt them. So while the governor's brief is written as if he is the sole entity standing between Wisconsin and the coronavirus, it simply isn't true. In fact, his unilateral approach may be hurting Wisconsin by disincentivizing lasting solutions. Second, the governor's argument here proves too much. I'd submit there's a reason that their discussion of the equities comes before their discussion of the merits in their brief. The governor is baking into his equitable interest the conclusion that he actually possesses this authority. It can't be that any time the governor asserts a health and safety interest, even an important one, that it's impossible for citizens to obtain temporary injunctive relief. That would punch a huge hole in this court's equitable authority. If this court agrees that it's likely that the governor does not possess the authority to extend states of emergency indefinitely without legislative input, the interest the governor asserts is significantly reduced. And third, and I won't belabor this once again, the governor is seriously minimizing the interest on the other side of the ledger here. He's unlocked a unilateral access to some of the broadest governmental authority conceivable. And he's used that authority to issue an order that applies generally to all Wisconsinites and that itself reflects an extraordinary assertion of governmental power, a requirement that Wisconsinites wear something over their faces until further notice. Considered in light of the other factors, especially the plaintiff's likelihood of success, equity favors a remedy here. And finally, Your Honor, I'll just touch once more on the justiciability question, whether this court can actually adjudicate this action. Just a few quick points on this. First of all, we allow citizens aggrieved by alleged abuses of government authority to challenge those alleged abuses in court. My clients assert a harm imposition of the mask mandate through an unlawful emergency declaration caused by the governor, and the law, here the declaratory judgment statute, provides them with a remedy. And they're clearly within the zone of interest of the emergency power statutes, which are designed for the protection of citizens. Second, and more generally, it's especially when the political branches are working together that judicial review may be called for. It's the Tetra Tech plurality states at paragraph 45, the separation of powers is not for the benefit of those who hold those powers. It's the bedrock of liberty. We don't have a system whereby the legislature and executive may together acquiesce in the indefinite suspension of democracy. Third, the governor might be on stronger footing if the challenge here were to some executive fact-finding with no clear guidelines that a court could apply. We concede on page 6 of our brief that the COVID-19 outbreak constitutes a public health emergency. This court is not asked to review that. It's instead asked to review a legal question. When the legislature says 60-day limit unless renewed by the legislature, no other exceptions, may the governor evade that limit by serial renewals of the original declaration? That's exactly the type of question that courts review. Finally, as noted, the ability to rescind is not enough. The legislature has already spoken. It says that after 60 days, it intends that the declaration be rescinded and expire. And the ability to rescind is not enough because the legislature may not be able to agree and the governor may be able to redeclare. So in conclusion, Your Honor, you're not going to hear from...
Let's just back up a second. Has the legislature introduced any joint resolutions to terminate Executive Order number 90?
Not to my knowledge, Your Honor.
All right, I mean, they could do it tomorrow if they wanted to. True?
Sure, they could, Your Honor. But again, they've already spoken in the statute. They could have had that system where they needed to act to rescind, but instead they said, we're going to act now when we adopt the statute. And after 60 days, that power goes away. We don't want to leave it to chance whether we're going to be able to agree. We don't want to have to come in over and over again in times that by their nature may be exigent if the governor keeps declaring an emergency. We're going to make this easy for the court. We're going to say 60 days, then it expires, no exceptions. That's what they did here. That's the framework they've adopted.
And what, if any, text in the statute suggests that an emergency is singular, meaning once the governor addresses it in a declaration of emergency, that it ends after the 60 days, or the governor doesn't have the ability to declare a new one, as he did here with Executive Order number 90, even if it's based on the same underlying circumstances.
Well, Your Honor, there are a few things. I won't repeat. I think the canons of statutory construction that I mentioned here all show that, for example, the surplusage canon.
Right, but is there any text? Is there any text that gets at that? Is there anything that I'm missing in the text
Sure, Your
itself?
Honor. Sure, Your Honor. The definition of a public health emergency, for example, refers to a biological agent. It refers to the for example, the COVID-19 virus. We're dealing with that virus right now, and we were dealing with it back in March.
I understand that, but what part of the text limits it to just as the state calls it, a one and done emergency?
Again, I think the 60-day limit does, because if the governor could redeclare serially, the 60-day limit would be meaningless. I agree with Your Honor that it doesn't say in the statute, for example, the governor may not premise this on the same state of affairs, but neither do the emergency rulemaking statutes, which limit an emergency rule to 150 days. Yet the opinion of the Attorney General that we provided makes very clear that it was obviously the intent of the legislature that renewals not be permitted, because that would totally blow a hole in the entire point of a durational limit like the one that the legislature's imposed. Just as they did that in the case of emergency rulemaking, they've done that here.
Thank you. Let's turn it over then to the Governor's Council, Mr. Hector. A couple of points to you. If the 60-day limit is to have any meaning, it's got to mean 60 days, doesn't it? I mean, it can't be, a governor cannot come along and just add successive executive orders one after another and undermine the text and the meaning of that 60-day limit.
Your Honor, that's absolutely correct, that 60-day limitation does play some function in the role. But it does exactly what the law says it does. It imposes a temporal duration on a single state of emergency declaration. It does not purport to alter the definition of disaster or public health emergency, and it does not confine the governor's ability to declare a state of emergency declaration in the first instance. In turning to the definition of a public health emergency, I think both parties agree here that that includes an occurrence of a novel illness that presents particularly acute dangers to the health and welfare of Wisconsinites, either by posing a significant risk of a large number of deaths, serious disabilities, or widespread exposure that may lead to those kind of dangers in the future. The word occurrence is broad, and when we use it in our everyday language, it covers not only events that arise out of circumstances that may already exist, it's also used frequently with respect to events that reoccur with some regularity. So whether the surge of COVID-19 cases in September 2020 is looked at as a new condition, a change in conditions, or a recurrence of extraordinarily high viral transmission rates, it falls squarely under that definition. I think I heard my friend on the other side say that of course there's cases where there are superseding events that may change conditions enough that it warrants another state of emergency declaration. Well, the data here is screaming out that unfortunately, Wisconsin right now is in a very different and much worse situation than it has been. Even when compared to a few weeks ago. I mean, if you look at September, the transmission rates have more than tripled. We've had 94 or more reported deaths in the past 5 days. We are now at an all-time high in terms of our average number of reported deaths on a daily basis. Last I counted, there were 25 days in September and early October where there were a higher number of new positive COVID-19 cases in this state than when compared to any day in the first 6 months of the pandemic. So
I didn't hear Mr. Lococo argue that there isn't emergency circumstances, that there isn't that public health crisis. What I hear him saying, though, is that once that exists and the governor issues a declaration, there's 60 days of extraordinary powers given to the governor so that the forces of government can then marshal itself behind a more long-lasting permanent solution. That's what I hear him arguing.
Well, to address that that part of his argument, I mean, I think that the statute is clear with respect to the term occurrence, that the emergency measures are flexible enough that they can respond to a change of circumstances. And I think an example would highlight sort of the absurdity of the plaintiff's atextual and narrow reading of the law. Say you have a river that's prone to recurrent flooding. It floods for 5 weeks, then it subsides for a few weeks, and then it starts rampaging across portions of the state. It can't possibly be the case that the governor needs to sit down and say, well, golly gee, did the water subside enough so that this represents a distinct disaster? The text of the law is not so narrowly confined. It empowers the governor to declare a state of emergency in response to a disaster, whether or not that disaster emerges out of a change in circumstances or it emerges out of circumstances that in some ways may have already been present. Plaintiffs characterize this as the exact same pandemic that we've been dealing with this entire time, but the facts unfortunately paint a very different picture. Taking a step back, Your Honor, I think your framing of this case at the outset was absolutely correct. Under the plain language of the law, the governor has the discretion to determine whether a state of emergency exists in the first instance, and the legislature has the authority to revoke that state of emergency through passing a joint resolution if it disagrees. That plain language in the process of the law forecloses plaintiffs' claims for a few different reasons. I mean, to begin with justiciability, the plaintiffs have not set forth a judiciable issue for a couple of reasons. The first is that process that I just talked about. The plain language of the law leaves the determination around a state of emergency with the political branches. And I believe that this court should keep it there because that's where the law requires it to be. But the plaintiffs have also not alleged a cognizable legal injury with respect to their claims. I mean, it's important. Yes.
Before we get there, can we just go back for a second? Let's take Mr. Lococo's point that, all right, we have a governor and a legislature who work in concert with one another, and they allow these extraordinary powers to just go on ad nauseum. And the legislature has no desire or inclination to check that power, and it's clearly an abuse of power. What remedy, if any, do ordinary people in Wisconsin have against that form of abuse of power?
So I think, Your Honor, my argument is that the plaintiffs here have not presented a justiciable issue, and that's because they base their claims entirely on Wisconsin Statute 32310, which, standing alone, imposes no burden on their everyday lives. There's no legally cognizable injury that they have from a state of emergency declaration, and there's no private right of action that law gives them to simply challenge a state of emergency declaration because they disagree with it. However, to address your question, I think that there is an important but narrow scope of judicial review that may exist with respect to the propriety of an underlying state of emergency declaration. The framework for challenging emergency orders has been well settled for over a century since the Supreme Court's decision in Jacobson. Plaintiffs have every right to challenge emergency orders that actually impose a burden on them. Plaintiffs here chose not to do that, but they certainly could. And if they did, I think the core question would be whether that order comports with the governor's authority under WSStat 32312 to issue orders that are necessary to protect public health, public safety. But as part of that review, I think the court could consider the propriety of the underlying state of emergency declaration. That review, however, would necessarily have to be highly deferential because the role of the court is to determine whether the governor acted in compliance with the law. Here, the governor's role is to make a determination as to whether a state of emergency exists. So one could imagine hypotheticals where the governor acted in an arbitrary or capricious capacity and clearly went beyond his statutory authority. For example, if a governor issued an emergency order that on its face lasted 100 days, or if it was clear from the facts of the case that the governor was using successive emergency orders as a pretext to extend a single state of emergency beyond the 60-day limitation, I think that those would present at least judiciable claims that the court could review on the merits.
Yeah, but isn't that what they're arguing? They're saying that these are successive emergency declarations, just one back to back after another.
Well, I mean, that's what they're arguing, Your Honor, but that claim is completely unsupported by the facts in the record. They're sort of categorizing this as the same old pandemic and that there's no changed circumstances. But here, that is demonstrably not the case, and it's not how Governor Evers acted. The first emergency order here was declared on March 12th. That expired on May 11th, and the Wisconsin Supreme Court struck down the statewide safer at home order on May 13th. The second state of emergency declaration was issued on July 30th, more than 2 months later. So there isn't some temporal proximity that suggests that this is just the extension of the same state of emergency. And as the preamble in the state of emergency that we are currently under makes abundantly clear, it was based on a distinct change of circumstances that is presenting extraordinary dangers to the people of Wisconsin. So while the plaintiffs may characterize this as simply an extension of the same state of emergency, I think that the findings by the governor in his executive orders leave no doubt that he applied his authority in a reasonable fashion to recognize the surge of COVID-19 cases in September 2020 as a distinct occurrence that presented new and altered dangers to the state. In terms of, to circle back to just disability, there's also a second reason why I don't think that they present a justiciable issue here. And that's because they haven't presented a legally cognizable interest. Again, they're basing their entire claim on 323.10. That statute doesn't affect anything with respect to their zone of interest. It doesn't require them to do anything. It doesn't require them to refrain from doing anything. And while they make much of the fact that plaintiffs are forced to comply with the mask mandate under Emergency Order 1, I don't think that that's sufficient to establish irreparable harm. I mean, after all, in the mine run of cases before this court, aggrieved parties are going to say, as long as this case isn't resolved, I am facing some sort of unfairness, whether it's a disputed piece of property that hasn't come back into my possession, or it's a contractual breach and they want that remedied immediately. They haven't shown any harm that can't be remedied down the line. In fact, while they focus on wearing masks in this oral argument, their briefs really only assert this ephemeral interest in having their view of the law vindicated, completely divorced from their everyday lives. And that can't possibly be enough to establish irreparable harm. Otherwise, that standard just becomes meaningless. And for the same reason, it shows why the public equities in this case overwhelmingly weigh against the issuance of a temporary injunction. When deciding, yes.
I was going to say, what is it going to take to get the case to the point where a final judgment can be entered?
I think it depends on the scope of factual discovery that the plaintiffs want, frankly. I mean, we've presented facts to this court that show why Wisconsin is in a very different place in terms of the pandemic, but they seem to be taking issue with that characterization. I mean, I think if this is just legal issues, we could have expedited briefing and we could move this along pretty quickly and have summary judgment motions sooner than later. But that assumes that the plaintiffs will agree with our characterization of what's happening right now. And I'm just not sure that they would agree with that. So there may be some limited factual discovery that's needed before the resolution of this case, Your Honor.
Because it's one thing to say, for example, deny a temporary request for an injunction, knowing that in a month this case is going to be resolved on its merits with a final judgment. It's another thing to deny their request for a temporary injunction, knowing that the case is going to be tied up in litigation and discovery for the next 12, 24 months. Those are two different situations.
Yeah, Your Honor, and I certainly don't think that this is the sort of case that would call for months-long or years-long discovery. I think the discovery period could be fairly quickly, and of course, it's in the court's discretion to issue an expedited schedule for briefing if it so chooses to do so. With my point in mind that I simply don't know what sort of discovery the plaintiffs will want, I can't imagine the scope of discovery in this case is going to really prevent the resolution of these claims in fairly short order.
All right. Did you have any final thoughts, Mr. Hector?
Well, I did want to address the weighing of the equities as well as the plain language of the statute, but I will try to be as brief as possible, Your Honor. So with respect to the weighing of the equities, this court in deciding a motion for a temporary injunction sits in equity and certainly can consider the competing claims from the parties with respect on the effect of the requested relief on the public. Here, the public equities weigh overwhelmingly against issuing a temporary injunction. The only stated interest that the plaintiffs have in their filings is this ephemeral desire to vindicate their view of the law. And to the extent that their argument today is taken into account, the harm that they propose is that these plaintiffs must comply with the mask order. And it's not even clear if they are wearing masks or if they feel like they fall under one of the exemptions in the order. On the other side, the public equities, it's hard to overstate because it would be removing what is right now the only statewide public health measure addressing the COVID-19 crisis. And we see that in the data with the reported deaths and the reported case rates. I mean, those two interests aren't comparable. They're not even in the ballpark. And as such, that presents an independent reason for the court to deny plaintiff's motion, which is, by the way, why we present it before the merits, because I don't think the court needs to reach the merits. I think the equities alone militate against granting the motion. In terms of the merits, I want to return to that word occurrence, because that's the plain language of the law. Plaintiffs give lip service to principles of statutory construction, but then they jump immediately to canons of interpretation. I mean, that's not how things work. We start with the text, and if the text is clear, that's the end of the matter. Here, the term occurrence is necessarily broad, and in our everyday language, it's used in a variety of ways, including with reference to something that may arise out of a change of circumstances or the recurrence of a particular event. Under that plain language, there's no question that a surge of COVID-19 cases represents an occurrence that falls squarely under the definition of a public health emergency. And that example I brought up before about a flood shows why. If there's recurring flooding, successive flooding doesn't suddenly fall outside of the statutory definition of a disaster. In fact, what plaintiffs want to do is they want to remove an entire category of catastrophic events from the governor's emergency measures, which unequivocally fall within the definition of a disaster or a public health emergency. To end, Your Honor, I do want to address, again, one of the questions you brought up, and I think the main point that my friend on the other side has been making, which is the 60-day limitation would somehow be rendered meaningless unless the court adopts plaintiff's view of the law. But the 60-day limitation, it does exactly what it says it does. It provides a temporal duration on a single state of emergency. It does not alter the plain language of the law, and because under that language, Governor Evers' executive orders were consistent with his statutory authority. I mean, that's really the beginning and the end of this case.
Why is it there then? And if the governor can end it when he or she wants to, and the legislature can end it whenever they want to, what's the point of having 60 days? Why is it there?
Well, Your Honor, I think as I said before, it functions as a temporal limit for a single state of emergency declaration. So, the governor can't issue an order that's on its face, goes for 100 days. And I think if the plaintiffs could really show that the governor was using successive states of emergency as a pretext to extend a state of emergency based on unchanging conditions, that would present, I think, a far different question and may give rise to a valid challenge under the law. But, it's easy to imagine hypotheticals where that might happen. But this case simply doesn't present reason to sort of, this case just presents something that's completely different.
Thank you. Mr. Lococo, I'll give you the final word.
Very quickly, Your Honor. My clients have been under this mask mandate in some form or another since July 30th, and I certainly can appreciate the court's questions about how complex this case will be. But again, I would ask the court not to minimize the harm to our clients. It's an invasion of their personal liberty, and it's been going on for a long time now. On the justiciability question, just to provide an analogous situation, and we don't mention this in our brief, I'd be happy to provide citations, but just this last year, the Wisconsin Supreme Court heard a challenge to Governor Evers' veto authority. That was brought by taxpayers. That's a perfect example of a case where you might say that it's simply between the political branches, but the Wisconsin Supreme Court decided it was justiciable, just as the Michigan Supreme Court did in deciding their case at the end of last week. To my knowledge, there are no exemptions that apply to my clients. There's certainly nothing in the record that says that there is, so that shouldn't be a consideration for this court. And finally, I just think it's important for the history of this case. During the period between the first and second emergency declarations, Governor Evers was trying to work through his Secretary of the Department of Health Services to exercise pretty much the exact same emergency powers outside of the state of emergency. The Wisconsin Supreme Court declared that unlawful in Palm. So that's, we submit, why there's a space in between the first and second declarations. Thank you, Your Honor.
Another question just came to mind. What, if anything, should I take from the legislature's inaction to rescind the governor's order? Should I view that as acquiescence of what the governor is doing, approval of what the governor is doing, or is there some other explanation about why the legislature hasn't stepped in? I mean, they could end it tomorrow. That's why this is something that's really weighing heavy on my mind.
I think there's two answers to that, Your Honor. There's sort of the formal question and there's the practical question or answer. Formally, you shouldn't read in anything to that because the legislature put into their statute the rule of decision it wanted you to apply, that if they don't act, that's what you should use to interpret their intent. After 60 days, it expires. Practically speaking, the legislature has come in and said in its amicus brief that the reason it's not going to step in is because the governor can simply come back and reissue another declaration of a state of emergency. And in our view, it could do that potentially by changing, tweaking the declaration a little bit. As long as the governor is able to extend based on changing circumstances, he will virtually always be able to reissue a state of emergency.
All right. You have both given me a lot to think about. This isn't an easy issue. This is a very complicated legal issue involving statutory interpretation, constitutional implications, and other things. I thought the briefing was outstanding. Your arguments today were likewise outstanding. I'm going to have to take the matter under advisement so I can think about it. I will issue a written decision. I appreciate the time sensitivity of the nature of the request for a temporary injunction, so you have my promise and commitment that I'm going to devote my attention to this and get it out very, very quickly. But I do have some things to think about, so I'll have to take the matter under advisement. Mr. Lococo, is there anything else that you'd like to say for today's record?
No, thank you, Your Honor.
All right. Mr. Hector, anything else?
Your Honor, I would like to answer that final question that you directed to Mr. Lococo, if that's okay.
Go ahead. I gave him an opportunity. It's only fair that you have an opportunity too.
And I just wanted to note, going back to your original characterization of this case, I mean, that is the remedy that the legislature has here. They're a co-equal branch of government, and in order to terminate a state of emergency declaration, they have to take a political act. They have to pass a joint resolution. Given that language in the statute, it can't possibly be the case that they can have the courts make that decision for them. Thank you, Your Honor.
Thank you, counsel. This hearing is concluded. Court is adjourned.